Alami versus Deutsche Bank. And Mr. Vesley, I think it's to you, sir.
Good morning. May it please the court. I am Brandon Vesley from the Florida Appellate firm. I have the privilege of representing Osama El Alami, who's the appellant in this case, and I would like to reserve 5 minutes for rebuttal.
Sir?
I'm sure the panel is familiar with the facts of the case, but I just wanted to talk about the crux of our case, and that is the 2014 judgment that was in the case with the same parties back in 2014. It was a 2010 case, 2014 judgment. I'm sorry?
Because I have a question on the front end.
Sure.
You take the position that in the earlier foreclosure action, that the court declared the mortgage void because the legal description had been attempted to be corrected without anybody's consent or involvement or knowledge, and similarly the deed. So if the deed and the mortgage were void, how does your client have standing? Because he's not an owner. If the deed's void, he wasn't conveyed title. Therefore, he's not an owner. So how does he have standing?
Your Honor, I haven't thought about that, but he was sued. So his standing is not bringing the case, it's responding to the case.
Well, yeah, but that's true. But it seems to me, if your theory is correct, that these instruments were void and we're bound by them pursuant to res judicata and collateral estoppel, your client's only exposure in this case, or your client has no personal exposure in this case, because if the deed was void, he can't be exposed to a deficiency because the mortgage at two was void, and therefore all that can happen is that the bank can foreclose against the house and take it back. So again, if your client's not an owner, I don't know how he really is, why he's in this case, based on your theory, and he certainly, on your theory, is not going to be exposed to any deficiency.
Well, that's not, well, they actually brought a claim on the note as well. And so
But that's different than a deficiency. That's no one's disputing that they still have a claim for even I think you argued that the bank still has a claim on the note.
That's correct.
He signed the note, he borrowed it, and that has nothing to do with the proper description.
That's correct. You're right. And that's what we argue. And basically we're saying you can't foreclose the mortgage because the mortgage is invalid. It's been voided essentially by the prior judgment, which was never appealed.
Well, I don't follow again how you have standing to make that argument, because your position is the mortgage was void because the deed was void. And therefore he could not have conveyed the mortgage. He may still be obligated pursuant to the note or the contract. But in terms of the foreclosure, the equitable action to foreclose the mortgage, I don't know how he has standing.
Your Honor, they sued my client for foreclosure. So he is responding to that by showing res judicata collateral estoppel based on the 2014 judgment, which clearly states that the mortgage is invalid. So his standing is to say, hey, we had this case. We already went through this. The court found that it was invalid. If you didn't like it, you could have appealed it. You could have challenged the magistrate's ruling. You didn't do it. You waited 3 years. You bring the same case against me and say that this mortgage it needs to be foreclosed. It's exactly the same case. And so he has a right to defend himself and raise these affirmative defenses, which he did clearly.
Well, what's he defending himself from, though? He's obligated on the note. They have a right to sue him on the note. No one has declared the note void. So he's defending himself on a foreclosure action, which if it's void, he has no exposure on, zero.
He's exposed on the note. They want to foreclose. They want him out of the house.
Well, he should be out of the house. He didn't get a deed. He had a void deed. He's never been rightfully in the house from day one.
There's estoppel issues.
If he got a void deed, he didn't get title. He didn't get anything. He got air. So he's been living in a house he has no right to be in all this time, on your theory.
And on their theory, they have no right to foreclose on that house. They have a note.
But that is, your dog's not in that fight.
They brought us into that fight, Judge.
Well,
They brought it. We raised it. The trial court should have recognized it. The court didn't find that the court found that they had a right to foreclose the mortgage despite our arguments. And how do you not have standing to defend yourself and say you don't have a right to do this when clearly the judgment from 2014 said they don't have a right to do this?
and that same judgment said your client didn't get good title.
That may be, Your Honor, but they brought us in this fight. We're here. We have every right to defend the case and present this argument that res judicata precludes them from doing what they're trying to do. And it's very clear from the 2014 judgment that they can't do what the court allowed them to do. They should have dropped their foreclosure claim and proceeded on the note only, and then that would have been a different situation. But they didn't do that. The court.
Well, let me ask you
allowed them
about
to
res
close.
judicata.
I'm sorry?
Let me ask you about res judicata. You said it's the same suit. Are we sure about that? Because there's tons, to use an inexact quantitative term, tons of case law out there that says you sue on a different default date, and that's not barred by res judicata, right? Because it's not it's not the same thing sued for, right? You defeat that necessarily element of the necessary identity for res judicata, right? Would you agree that there are case law that says a bank can bring who has lost a foreclosure suit can bring another foreclosure action based on the fact that the identity for the thing sued for is not established under res judicata because it's a different default date?
I agree, Your Honor, that there is case law that says that. That's not this case. This case is about.
Why not? Well, on that aspect, isn't this a different default date?
Actually, I'm not even sure it's a different default date. The fact of the matter is, it's been in default for years. But the fact of the matter is,
right. So they can't. So they can't. All right. So let's just presume I'm correct that that's a different thing sued for. And under normal circumstances, the bank would get around res judicata because they brought it into their claim. So if it's not res judicata, then the problem is that your only preclusive doctrine that it's applicable is collateral estoppel, issue preclusion. And tell me how the issue of reformation, in other words, what I understand you to mean is that you're saying it's void. We can leave aside whether that's the correct term, but that the magistrate's report said the altered deed is unenforceable, right? How does that foreclose? In issue preclusion, how does that adjudicate the issue of whether the unaltered deed can be reformed?
the reformation is something that should have been raised back then, and because they.
But that's it. But that only applies to res judicata. Only in res judicata do we give preclusive effect to issues that were not adjudicated but could have been adjudicated. But under issue preclusion, you have to have adjudicated that particular issue. So how does a magistrate's report and a circuit court adopting that report, adjudicating that an altered deed is unenforceable, adjudicate the issue of whether the unaltered deed can be reformed?
If we're looking past res judicata, they could have raised that, but unfortunately they raised it too late because the statute of limitations prevents them from raising reformation. And also, in order
are you agreeing or disagreeing that those are two separate issues? One, whether the altered deed is unenforceable, and two, the issue of whether the unaltered deed could be reformed.
If the res judicata does not apply, and collateral estoppel is what we're relying on, the collateral estoppel argument is that they don't have a mortgage that they can enforce. Now, if they're trying to reform that mortgage, they needed to do it back then because of the statute of limitations, Your Honor. The 5-year statute of limitations applies in this case. It's clearly applicable. It talks about, I can give you the site for it.
All right, so for the sake of discussion, I'm not saying you're conceding, but we're moving past my question and getting to a fallback argument, which is that if we don't have res judicata and we're only operating under collateral estoppel and the issue sought to be precluded was not adjudicated, that now this under reformation can't be brought because it's barred by the statute of limitations. So I have a question for you. Is reformation a cause of action? I know it's pled as a claim, but isn't the cause of action the breach of the note and the foreclosure of the mortgage? And reformation is just an equitable remedy in service of that cause of action?
Well, for res judicata purposes, it is part of the same claim because it's something that could have been raised back then. If that's
No,
what
for the
you're
purpose of statute of limitations.
statute of limitations applies to reformation
Yeah.
claims directly. There's case
Now, I
law.
know you have the Hogg case, right, that you're relying on that says, you know, this is a reformation is a cause of action based on a written instrument, or, you know, and there's debate about written versus unwritten, but cause of action based on an agreement. Is it really a cause of action standing alone? That doesn't need to be in service of the actual cause of action, which is breach of that agreement, or
It's a precursor to the cause of action because they can't bring the cause of action unless the mortgage is reformed. So it's part of the cause of action to reform the deed before you can foreclose on it. And the fact of the matter is, the statute of limitations applies to equitable claims. 9511 2B states within 5 years, a legal or equitable action on a contract obligation or legally founded on a written instrument. This was part of their cause of action. Certainly applies.
do you have any it might be Hogg, right? Tell me, is it Hegg? I don't know. But what are the cases, you know, that the bank has said, you know, that has made sort of a, I don't want to say public policy argument, but a argument that this is an unworkable way to read the limitations period to apply to reaffirmation and foreclosure actions. What cases do you have in which, you know, a bank said, well, look, you know, yeah, obviously the default was such and such, you know, we beat the statute of limitations, you know, on the, you know, the default date or whatever, but we need to reform. And then you're saying, well, oh, but that mortgage was entered into 20 years ago. That's more than 5 years. You can't reform it to what cases?
Your Honor, I don't have that case with me other than the Hogg case. But I will say that there's another reason why they haven't proven their case for reformation. I don't want to change the subject, but there's another reason, and that is that there was no evidence. They didn't bring in, you know, trying to reform a deed. They didn't bring in the grantor of the deed to the case. They didn't present any evidence as to what transpired back then. And with regard to the mortgage, I mean, the deed is really the crux of it because the deed is invalid. And
Let me ask you this about not bringing in the grantor.
sorry,
What'd you say, Judge Morris? I'm sorry.
That's all right. Go ahead, Judge Atkinson. I'll after you speak, I will.
Oh, well, I was going to say real quick. You brought up Salam. I think it's, you know, you said, well, you didn't bring in Salam, the grantor. Like, you know, I just want to ask a practical question. What does he care? You know, he thought he was conveying C, and then they're reforming a deed to, you know, convey less than, you know, one reading of the deed would indicate. So you want to bring him in and say, hey, I want to make sure that you didn't also want to convey things you didn't intend to convey. I mean,
that's the
is that
sort of
really
evidence. That's the sort of evidence that was found to be important in other cases where they're reforming a deed based on mutual mistake.
so I have a question to this. So if that's the case for reformation, you know, in other words, but for the practical purposes of this case, lot C, parcel C collateralized the loan. So you can't bring in you say, oh, we can't locate the grantor in order to reform it to eliminate a problem where the face of the document putatively conveys more than intended by the parties. But the undisputed portion that was conveyed collateralizes the loan.
Well,
And that's all they want to foreclose on. So why do you need the grantor for that reformation for the purpose of foreclosure?
These are assumptions that the court is making, and they needed to prove it. They didn't prove it. There's no clear and convincing evidence to show that they're entitled, that there was a mutual mistake and they're entitled to reformation as a result. And that's, you know, so that, again, that's our secondary argument. Actually, it's our third argument after our statute of limitations argument, and also as to race
Well,
judicata.
let me ask you this. I mean, isn't the testimony of the buyer evidence? He says, I and the seller only intended to convey C. Isn't that evidence
And
of
just so
mutual
you know,
mistake?
you're at 15 minutes.
To answer your question, the evidence is that there's no evidence. The evidence that was presented, there's no evidence to show the mutual mistake. Now, the fact that my client recognized that there's a piece of property that collateralized the loan doesn't mean that there's a clear evidentiary position regarding what that deed should have had in its description at the time. So, I mean, it could be that the seller intended to do something completely different, but we needed that information. There was no evidence of that. And again, there was no evidence at all presented on mutual mistake. Not just you're saying my client's testimony. I mean, okay, granted, there may have been my client's testimony as to what he intended to buy, but what the seller intended to convey, there was no evidence of that. And they could have brought that person in. Basically, what this court is doing, it is looking for all these excuses for the bank to do their job. The bank hasn't done their job. They could have appealed this back in 2014. They didn't do it. They could have brought this sooner. They didn't do it. They could have brought the reformation action back in 2014. They didn't do it. Why are we looking for all these excuses? Let them proceed on the note. That's what they have. Nobody's questioning whether it's valid. They have a note. Let them proceed on the note. Why are you going to take the house? That's basically what the court did. Said we're gonna foreclose on the house. So I'll reserve the rest of my time for rebuttal. Thank you.
Okay, you'll have 3.5 minutes when you come back.
Thank you.
Ms. Mello, it's your time.
Good morning, may it please the court. Kim Mello with Greenberg Trauig, representing the trustee in this matter. The borrower in this case purchased the property at issue. He executed a note and mortgage. He made payments pursuant to the loan. Then he defaulted. He has not made a payment on this loan for over 17 years, and he now owes over $1 million on this loan. Despite these facts, the borrower here essentially wants a windfall. He basically wants to maintain possession of this house that he has not paid for.
But what about the statute of limitations argument? I mean, it's really, that's an argument that you got to pay careful attention to. Had 5 years from knowledge that there was a problem with the legal description to bring a reformation action. I mean, how do you address that? It looks like the 5 years is long run.
So with respect to the statute of limitations issue, I think, well, there's a couple of points. First, I think before you even get to the statute of limitations issue, we have made the alternative argument here that reformation wasn't even, or isn't really even required as a remedy here because the property,
of the tax parcel number and the address on the deed. It
exactly
sufficiently identifies it, and the cases have said that for a long time,
and
right?
the cases have said that for a long time. So you may not.
Let me ask you about this on that. If under the theory I was exploring when I was speaking to opposing counsel, if it's issue preclusion, is that precluded? I mean, we may not agree with the magistrate's report, but is that precluded on that issue? That was adjudicated, right? That magistrate said this is unenforceable. But I guess let me answer my own question. Is your answer to my question that no, I'm focusing on a different thing. The unaltered deed is enforceable, is what you're saying. In other words, the altered deed was unenforceable because the magistrate said, he or she said, you know, this is an altered deed that I can't enforce this. But are you saying that the issue is that the unaltered deed is enforceable?
Well, I think to answer your question, I think we need to take a step back and look at the 2014 final judgment, because I think if you look at the 2014 final judgment, it's very clear based on the findings that the judge found and limited it to this case because basically the evidence that she had, and look, we don't have the transcript. I mean, we have a couple of documents from the case and we have the actual order from the magistrate. But if you look at the language, it's very clear to me that she says if the deed is defective, she never makes a finding that the deed is void. And she says she finds there's no legally enforceable mortgage in this case. And then in her specific findings, she goes on to say plaintiff does not have standing to bring this action, in that while it or its predecessor in interest was the holder of the note at the time of the institution of the action, there was no legally enforceable mortgage in existence at that time. So I don't think that you can take this order and say there was a finding that the mortgage was altered and therefore forever legally unenforceable. There's nothing in the order that states that. And I mean, that's the real whole purpose of reformation, right? Is so that when you have an issue, you can correct a legal mistake. Now, the magistrate, I mean, she used the word alter, but really, I mean, when we look at this, is this really an alteration? It's really not alteration in the sense that they were just trying to correct a legal mistake.
Here's the problem. She did in fact find it was not enforceable. Whether she's right or wrong, she found it was not enforceable because of these unilateral efforts to correct the mortgage, which quite frankly, honestly, are common practice in the real estate business. It's not uncommon to have legal descriptions that are not correct, and they're re-recorded deeds and mortgages done by the closing agent to try to correct what the parties mutually thought they were doing. But that's beside the point. But the point is, she did find, because of these unilateral efforts to correct the legal, the mortgage was not enforceable. I didn't see anywhere where she used the word void, but she just basically said it's not enforceable. So why isn't that the law of the case, or res judicata, or collateral estoppel as to this issue in this case? Why aren't we stuck with that?
Because in this case, what the trustee did was it brought both the mortgage foreclosure action and the reformation action essentially to correct the fact that there was a problem, right, with the fact that they basically filed the re-recorded mortgage and he didn't sign it. The re-recorded mortgage basically just has the correct legal description in it and not the legal description of the broader.
It was a pretty big error in the legal. It wasn't some little scrivener's error. There's a triangle A that included in triangle A are smaller triangles B and C. And the original deed actually conveyed all of A when it was only intending to create little c. So if I've read this all correctly, both the bank and the buyer got way more than they bargained for. They were in a better situation. So the efforts to correct the mortgage were to reduce it to the smaller triangle C within the big triangle A. But nevertheless, it was done. And I don't think there's any real question that the reformation action is barred by the statute of limitations. And you have now said that you don't need to do it anyway because the property was correctly described by the tax parcel number and the address to the property. So where does that leave us? So we have a foreclosure action that is probably not prohibited, by the previous action because there was no finding of voidness. there was only a finding that it was not enforceable because of these unilateral efforts to correct the legal description. But the case law clearly says tax parcel numbers and addresses are enough to identify the property. So why don't we have just a straight foreclosure with no reformation and based on the legal tax parcel number and the address of the property? Are we prohibited from doing that? I know you're going to say no,
I don't think no, I mean, and that's why I made, the argument in the alternative, because I don't think that foreclosure is barred if reformation is unnecessary here. We filed a new foreclosure action based on a new default date, which we were clearly permitted to do under the law. And therefore we can clearly proceed with foreclosure, and there's been no challenge to the foreclosure, itself.
Well, if the deed, going back to my argument I raised with Mr. Vesley, if the legal description has been determined to be void by the previous court, it's void in the mortgage and in the deed. So how does the buyer have standing to defend the foreclosure action? Clearly, the buyer has standing to defend the action on the note because that's different. But if the buyer never got good title, why is the buyer involved in the foreclosure action?
I mean, he doesn't have title, so he has no. I mean, if there was a finding that the deed was void, in that action, you're correct. I mean, he doesn't.
But you're still suing on an equitable lien,
would have
right?
never passed to him, so he has no right to be in the house.
Yeah, but you're suing on the equitable lien, correct? The
Yes.
equitable lien is separate and apart from the mortgage itself. So whatever the problems with the mortgage are, it doesn't impact your cause of action on the equitable lien, right?
Right. We would all, yes, we still have the right to the equitable lien and breach of contract, but that said, I mean, because I don't agree that the statute of limitations has expired. So I do want to address that. And I also want to briefly address the fact that in the final judgment itself, the court found that the defenses were legally insufficient. And, there's a difference between pleading and proof, of course. So in the summary judgment proceedings, we raised the issue that the affirmative defenses were bare bone. They were legally insufficient. In the final judgment, the court made that finding. On appeal, they did not challenge that. So,
where is it? So you're the order on appeal didn't say that they'd been overcome. It said they were insufficiently pled. Where is that in the order?
That is page 976 in the final judgment. And what the court says is the borrower has no valid or legally sufficient defenses.
So that you're saying that means they said they were insufficiently pled?
That they were
I read the brief, but I mean, I'm just be frank. I'm trying to get myself to where you're going here.
Well, I mean, I think legal insufficiency, it's a matter of pleading. I mean, I think if you read the cases, whenever it's insufficiently pled, they're legally insufficient.
So you said 976 again? I'm sorry, I just for the purposes of argument, can you
it's on page 976. It's actually
what paragraph?
It's at the very bottom of the page. It's L, it's sub L. If you look at the final judgment, it's in sub L.
Okay.
And then the court
let's just say we disagree with you that actually says that they were insufficiently pled, and instead that was just the trial court. I can't speak for my colleagues, and I won't even speak for myself. But I want to ask you a different question. Let's say that the bank had just brought back in the last time they brought a foreclosure, or this time they didn't try to reform. They didn't. There was no alterations to the deed, and they just said, look, this mortgage collateralizes parcel A, which includes B and C, but we're only foreclosing on parcel C. And the reason was because, they realized that there really wasn't, that there was no meeting of the minds, that really B was never conveyed. What would be the problem with that? Couldn't they just do that without reformation and just said, hey, here's our mortgage, it collateral, we have a mortgage on this entire parcel A, but we're doing the right thing here. We're just going to we just want you to give us a judgment of foreclosure for C.
Right, and if I'm understanding your question, I mean, I just think that goes back to the whole point of whether reformation here was
Well,
even
I think I'm making
necessary.
an alternative theory, not just, and I'll ask Mr. Vesely the same thing. I'm not just, well, hey, all this case law says you have a legal description and an address, and I mean you have a, that parcel, that's fine. This kerfuffle over the parcel numbers, letters doesn't matter. But I'm saying, like, what if you just get past that and say, look, on the face of this, the whole entire parcel A collateralizes the debt, but let's not get into that. We're only asking to foreclose on C. Could they do that?
I mean, I think so. I mean, I haven't specifically researched that, but I mean, as a practical matter, it makes sense that yes, that they could do that. I mean, look, foreclosure, I mean, it's an equitable remedy here. I mean, like if we take a step back and we just look at the big picture here, we basically have a mistake, right? That everybody knows was a mistake. I mean, the borrower here clearly said he intended to purchase the property. I mean, he paid on the loan. I mean, he admits it's his property in his answer. And now he's trying now to say, gotcha, because of these findings that were made in the 2014 judgment, which does not prevent us from being able to foreclose based on a new default date, which is exactly what we did. We brought the claim for reformation to correct the mistake. Borrowers never said, oh, that wasn't what I wanted. That's not what I I didn't intend to buy that property. He's never said that. Everybody knows that that's exactly what he was trying to do. So we're able to re-foreclose, and now, they're making this issue with respect to, the statute of limitations bars the reformation claim. So I think it's important for me to address that, because if for some reason this court finds reformation was required, I think when the court looks closely at the cases and also considers the unreasonable result, right, that would occur if the court found that the statute of limitations barred this reformation action, that it would be very, very problematic. When you look at the Engel case and the Corinthian case, the Engel case being out of the 5th and the Corinthian case being out of the 2nd DCA, granted, those cases dealt squarely with statutory latches under 95.11(6), but in both of those cases, the courts looked to 9511, which is at issue here, to determine whether or not statutory latches applied. In the Engel case, they said statutory latches does apply here because 9511 sub 3, I believe, or no, it was actually sub 2, the exact same subsection in this case, applies because we believe that an action to enforce a restricted covenant falls under the umbrella of the statutory provision, because the court read it as being limited to enforcement actions. The Corinthian decision subsequent to Engel out of this court dealt with an action to reform a deed. And in that case, the court essentially followed Engel and said, an action to reform a deed, it's not an action to enforce a contract. And therefore, we're going to find statutory latches does not apply. And I think the court made a pretty broad statement in there that statutory latches doesn't apply to any equitable reformation action. So it made a pretty broad statement on statutory latches. Then we get to the
Should this
Hogg.
court in Hogg have this court in Corinthian have followed Hogg?
Well, Hogg, you mean should the Hogg court have followed Corinthian? Because
Sorry to get that backwards.
yeah, Hogg's is the most recent decision, and so in Hogg's, unlike the Corinthian and Engel decision, which involves statutory latches, Hogg's didn't involve the statutory latches issue. It only involved the application of 9511 subsection 2. Now, what the Hogg's case dealt with is something factually dissimilar than what we're dealing with here, because in the Hogg's case, what happened was you had a developer that was developing a subdivision, and he put in the declaration that it only covered phase 1 when he should have said that it covered phases 1, 2, and 3. He made a mistake. Okay, he made a unilateral mistake in that case. The association years later came back and said, you know what, homeowners, a mistake was made. Will you consent to having your homes fall under the limitations and restrictions in this declaration? A lot of the homeowners said fine. A couple of them did not, which is what prompted the association to file the action in Hogg's. And so, of course, it's clear they're very dissimilar. One, we're dealing with a real estate conveyance, right, where we're just trying to correct a legal description. Another one, we're dealing with a unilateral mistake where years later they're coming back and they're trying to compel these homeowners to fall under the declaration. And what the court and Hogg's did, and I understand,
Ms. Mello, just so you know, you have 30 seconds left.
Oh, okay, well, I'll try and go super fast because I think it's important. But what the court in Hogg's did was, and I understand why they did it, they looked at the plain language of the statute and they said, you know what? We think that this is in trying to enforce this or reform this restricted covenant is under the umbrella of this statute. Okay, it is an action on an obligation. And I understand that analysis. Read the plain language, apply it. Here, I don't think you necessarily get there when you're dealing with this kind of a case. And moreover, if
You're
you
way
do,
over time now.
okay, I'm sorry. Okay. All right. Well, the rest of it's in my brief, but it wouldn't be equitable. It would lead to an unreasonable result, which you can't enforce the plain language if it's going to lead to an unreasonable result. And based on those reasons, I would request the court affirm the judgment, and I apologize for going over time.
That's okay. Thank you. Mr. Vesely, you have 3.5 minutes, sir. And you're muted.
Sorry about that.
Okay.
Thank you, Your Honor. I think we're kind of losing sight over what this case is really about. And that is that the deed and the mortgage were impermissibly changed after they were entered without doing it the proper way, without reforming them properly. And the Florida law holds that written instruments that have been materially altered and changed after delivery are null and void. So we have a void deed, a void mortgage. You can't reform.
Well, the altered version is void. That doesn't necessarily mean that the unaltered version is unenforceable.
Well, that wasn't accurate either, Your Honor. I mean,
Okay.
all the versions were wrong, and that's why they tried to make the change.
No. Well, they were wrong. Wrong is different than altered.
Okay, but
wrong meaning it didn't conform with the intention of the parties is different than altered.
So you're suggesting that if I go and alter it, the altered version can't be enforced because it's null and void, but the original, you could fall back on the original version, which was not accurate.
I'm asking you what the cases say. I'm asking you what the cases say. Do they say that the altered version is unenforceable, or do they say this agreement is now void ab initio?
I think that the deed, whether it's the altered deed or the falling back on the original deed, I think it's void at that point. They need to go and do it properly. They didn't do it properly.
Doesn't it matter who altered it? you know? What if the parties, the closing agent altered it, but the parties were like, "Oh, we didn't authorize the closing
Well, the
agent
court-
to alter
the
it.
court-
We agreed to convey this property."
I believe the court determined that it was altered on their side of the equation. Let's read some of the language out of the order. It is the magistrate's finding that the deed was altered and after its execution and before its recording and re-recording without the knowledge and consent of the seller or purchaser or borrower. It is the magistrate's finding that the mortgage which forms the basis of the lawsuit was altered after its execution and before its recording without the knowledge and consent of the borrower. And then she concluded that plaintiff does not have standing to bring this action, and that plaintiff, the Deutsche Bank, while it or its predecessor in interest was the holder of the note at the time of the institution of this action, there was no legally enforceable mortgage in existence at that time. No legally so if you're saying we could fall back on the original mortgage and then that would be enforceable because it wasn't altered, she's saying there's no legally enforceable mortgage.
Right. She's saying that. I'm asking you what the law says. We're talking about whether the magistrate was right here or not. I mean, the only reason we'd have to adhere to what the magistrate said was because of a preclusive doctrine.
That's right, Your Honor, and that is the law of this case, and so basically,
I'm asking you what the law is, whether the voidness that pertains to an altered doctrine necessarily makes the original unaltered doctrine void ab initio.
Your Honor, it's that is superseded by what the court found, which was not
We're out of time, Mr. Vesley.
which was not appealed and which was not challenged. Your Honors, just want to say real quickly that there's no.
You're out of time, Mr. Vesley.
Okay, thank you very much, Your Honor. I please hope that you reverse. Thank you.
All right. Thank you both very much. Definitely a very interesting case. We appreciate your help in trying to sort it out. Have a good day.